Welcome to Rock Solid IP, expert strategies for creating real value from your creativity and innovation.
Hello and welcome to Rock Solid IP, expert strategies for creating real value from creativity and innovation. Joining me today is Rob Wells, managing attorney with Rock IP. My name is Kevin Rosenquist. I am your host, and today Rob is going to unravel trade secrets. Rob, thanks for being here.
Hey, Kevin. Thanks for having me.
Let's start with what exactly a trade secret is and how does it differ from other forms of intellectual property like patents, which we talked about last time, or copyrights?
Yeah. A trade secret is essentially any information that you have within your company that you choose to keep confidential. It is anything that really kind of gives you a competitive advantage. As a litmus test, you can ask yourself the question, if this information became public, would it be worth as much? And if the answer to that is no, it wouldn't, then it's something that you're going to keep as a trade secret or pursue other types of IP protection for, either a patent or maybe a copyright or something like that. Unlike patents, trade secrets aren't registered. There's no expiration date. So while a patent is valid for 20 years, a trade secret can be valid and subsist for hundreds of years, potentially. What ends up happening, though, is trade secrets are only valid to prevent theft of your trade secret. So somebody literally opening the filing cabinet and pulling it out and stealing it, which means that confidentiality becomes important. You need to actually protect them and maintain their confidentiality. And the standard for protecting that confidentiality is reasonableness. Did you take reasonable steps to protect the trade secrets? A patent, on the other hand, gives you coverage for 20 years and you tell the entire world about it. So there's no confidentiality involved at all. Copyrights, those protect creative works like books or music or art, that type of thing. But trade secrets are, your secret weapon, the thing that you don't think anybody else can reverse engineer or create on their own or can independently invent.
Okay. All right. Interesting. And what types of business information are typically considered trade secrets? Could you give me some examples of what might be protected as a trade secret?
Yeah. So trade secrets can be just about anything that gives your business an edge, as long as it's not publicly known. So it can be your customer lists. It can be your sales data. It can be your pricing structure. It can also be more technical in nature. It can be something that you don't think that other people can reverse engineer. So for example, as long as you don't release it, it can be your internal code that you're putting onto just your internal servers and that you don't think people can reverse engineer. It can be, for example, the formula for Coca-Cola is sort of considered to be the gold standard for what a trade secret is. There's a very limited number of people who actually know the entire formula to Coca-Cola. Lots of people have pieces and parts of it, but only a very few actually know the entire secret for Coca-Cola. Back in the day, there was also a trade secret for what they called float glass. It was a method of actually creating really flat glass. Before that, glass was a little bit wavy. And the method that was created for this float glass trade secret, they just didn't disclose to anybody. They never let anybody see how they made their float glass. So it kind of covers the gamut of different things. But essentially, if it provides a competitive advantage to your company and you keep it confidential, it's a trade secret.
I can't believe no one's figured out the Coke formula by now.
Oh, it's known. But nobody has actually gotten Coke to tell them, and nobody has gotten into the safe where the formula is kept.
Okay. Well, I can tell you RC didn't figure it out. Royal Crown didn't figure it out. That's for sure. Ugh. We've seen some high-profile cases of trade secret theft, particularly in industries like tech and pharmaceuticals. How do courts typically view trade secret theft in those sectors? And are there any notable trends in those cases that you've seen?
Yeah. So courts really do take trade secret theft very seriously. This is literally where you've got somebody literally trying to steal your competitive advantage and something that you're actively trying to keep confidential. The Defend Trade Secrets Act, or the DTSA of 2016, even allows companies to bring cases in federal court as opposed to state courts. So that really streamlined enforcement. One of the trends that we're sort of seeing is a rise in international cases. There's cases where foreign nationals have come to the United States, gained employment at different companies, and actually tried to capture and take secret information of that company and take it back to their home countries. That typically isn't seen very well. So for example, some of the GMOs, the genetically modified corn or soy, that kind of thing. In that case, there were some nationals that came into the country and were caught literally trying to take samples out of the cornfields or out of the soy fields where plants were being grown. They get labeled by the farmers, and there were people actually trying to harvest them to see if they couldn't get the information on them and take those back. Or let's take one of my favorite cases, the case of Bimbo Foods. Are you familiar with Thomas's English Muffins?
Absolutely. I love those things. They're so good.
Yeah. Have you ever tried the generics? Or
yeah, we have a rule in this house that I do like. The bays are decent, but we have a rule in this house that we don't get generic English muffins.
Yeah. Do you know why? Why is the generic not as good as the Thomas's English muffin?
I don't know, man. There's something about those nooks and crannies.
That's exactly it.
Is it really? I was just, I seriously didn't even telegraph that. I didn't know that. Okay.
Yeah. No, that's exactly right. So Bimbo Foods has a recipe, and their specific recipe for making the Thomas's English muffin results in the perfect number of bubbles. And whether you're Hostess or a generic or anyone else, nobody else has succeeded in making the perfect Thomas's English muffin. Now, the recipe is known by only 3 people. And this is actually a case. You can look it up. It's only known by 3 people. One of those 3 people kind of decided to defect. He went to Hostess and he said to Hostess, "Hey, look, if you'll hire me and provide me with whatever salary he wanted, I will give you the recipe for Thomas's English muffins." Thomas's won't have the same strategic advantage, right? The same nooks and crannies that we all have grown to love, that crisp up just right and hold the butter. To Hostess's credit, they quickly went back to Bimbo Foods, who is the owner of Thomas's English Muffins, and said, "Hey, you guys should know that this is what's going on, and this is who approached us." There are criminal charges that can be filed for that. Yeah. So that was the result in that particular case. But I love it because it simply goes ahead. It demonstrates where and how trade secrets can be enforced. And on a very clear example, how a trade secret that for an extended period of time has not been discovered can be used and protected, rather than, for example, disclosing it in a patent application and saying this is the way to make the perfect English muffin, which would get you 20 years of protection. But Bimbo Foods has done a bit better than that and has been producing Thomas's English Muffins for however long they have without anybody ever figuring out how.
Wow, that's crazy. Why are trade secrets often preferred by businesses over patents? And what are the advantages, I guess, of keeping something as a trade secret instead of disclosing it for patent protection?
Yeah, so when you tell the world about your idea in a patent application, what the USPTO or US government gives you, and in other countries as well, they give you a 20-year monopoly or a 20-year right to exclude others from practicing the claimed invention. Again, the claims of the patent are the name of the game, but it's limited to a 20-year stint. You only get 20 years of protection out of that. By contrast, as long as nobody can reverse engineer it or independently invent your concept, you have indefinite ability to protect your patentable idea. Also, I think in the last episode, we talked about what can be patented. To the extent that what you have as a strategic advantage is something that cannot be patented, it's an abstract idea, or it's a business method that is somewhat basic or something of that nature, or if it's like pricing, or if it's your customer lists or your scheduling, for example, any of those types of things, those can't be patented, but they can be held as trade secrets as long as you make adequate, reasonable measures to protect the confidentiality of it and not let that kind of get out into the public.
And what do you generally recommend as far as best practices for safeguarding trade secrets? And what do you tell businesses that they should do to protect themselves?
Yeah, so there's 2 different things that actually matter for a company who is looking to make sure that they protect their own trade secrets and as well as not infringing anyone else's trade secrets. Let's talk about how to not infringe somebody else's trade secrets first. One of the first things that you should do is when you're onboarding a new employee and they're coming from maybe one of your competitors, there should be a clear discussion from your HR manager that probably verbally and in writing notifies them that you respect trade secrets and expect them not to use any of the trade secret information that they may have acquired at their previous employer. ideally that should set you up in a position where you won't infringe one of your competitors' trade secrets by virtue of hiring somebody. Then let's talk about the process for how to protect your own trade secrets. A trade secret program is really helpful. A trade secret program is typically a written document or a series of documents that, number one, put your customer or your own employees on notice, may put other partners or vendors, et cetera, on notice that particular pieces of information that you have are considered trade secrets. So it also requires identifying what those trade secrets are. And then it requires taking reasonable steps to protect the confidentiality of that trade secret. And that is kind of a fluctuating bar, if you will. It kind of moves up and down depending on how important that trade secret is to your company and how important it would be kind of industry wide. If what we're talking about is your customer list and a lot of people need access to your customer list, say all your salespeople, the bar for what type of action you need to take in order to protect that trade secret is probably a little bit lower than, say, the formula for Thomas's English Muffins. When we're talking about something that is higher, you probably do need to take additional steps. You probably need to go ahead and make sure that you separate, for example, who has access to what knowledge. So, for example, at Bimbo Foods, they would make sure that some people knew what ingredients were put in, but they didn't know what the mixture was. And other people knew what the mixture was, but they didn't know what ingredients were used or in what order, that kind of thing. And then strictly, make sure that you restrict the access to the original trade secret, whether that is through physical means. Make sure you lock your doors, make sure you require passwords on your computers, make sure that the trade secrets are kept on a device, for example, that is not accessible via the internet. All of those things can go into reasonably protecting your trade secrets, depending on, again, what the trade secret actually is.
Are you a Simpsons fan?
Sure, absolutely.
You remember the Flamin' Homer one?
I am not, no.
Okay. He creates a drink and Mo steals it from him. He should have done this. He should have done a trade secret.
Yeah, did Mo find the recipe?
Yeah, no, he shared it with him and then he stole it from him and profited from it.
See, there's the problem. He actually told Mo. If Homer tells Mo, it can't be protected as a trade secret.
Okay.
If Homer hadn't told Mo, then it could be considered a trade secret. And then if Mo came in under cover of darkness, for example, and found the piece of paper that it was written on,
It could be such a Mo thing to do.
Yeah, maybe. And then it would be a trade secret theft. And then Homer could sue Mo for trade secret infringement.
Okay. All right. See, I like practical examples like that.
Yeah. There you go. Straight out of the comics.
So Simpsons aside, if a company's trade secret is stolen or leaked, what legal recourse do they have? Can they take action even if the secret was not formally protected by like an NDA or something like that?
Yeah. Under the Defend Trade Secrets Act, you can sue for misappropriation even if there wasn't an NDA. So having one definitely helps. And that would be ideal, or a joint development agreement. But you would have to prove three different things. Number one, you have to prove that it is a trade secret, that you took reasonable steps to protect that trade secret. And number three, that it was stolen through improper means, right? Mo, under cover of darkness, stealing the recipe from Homer. If, on the other hand, you have, like in the episode, Homer disclosing the recipe, you'll have a hard time proving that it was a trade secret because you actually disclosed it. Or if Mo can prove, no, I created this. I saw what Homer was drinking and I thought it sounded good, so I made it. Then also, you wouldn't get trade secret protection. If you win, you could get damages and you could, for your economic losses. And in extreme cases, you could even get some punitive damages or attorney's fees. But prevention is always going to be better than the courtroom battle. So take those reasonable measures to protect your trade secret and just don't let it leak.
Yeah, I mean, it's got to be kind of a fine line because you were talking about, sales lists or client lists and all these other things that you got to share internally to some degree, but you also want to maintain confidentiality. So how can companies navigate that?
Yeah. I mean, it is a balancing act, right? The key is to compartmentalize. If you share the whole secret, only share the whole secret with people who actually need to know the entire secret, and then break it into parts for everybody else. Like I said, for example, if you're running a bakery, don't give anyone access to the entire recipe. Instead, let some people know the recipe, the ingredients, but only the manager knows the proportions. If what we're talking about is code to your, for your startup company, don't disclose that code to everybody and don't make it available to everybody. That code gets identified by only the people who are working on it, and other employees like your sales force, they don't have access to your code. That's really the best way to protect that kind of thing.
How common is it for companies to settle trade secret disputes outside of court? Do a lot of the cases go to trial, and what's the pros and cons of each?
Yeah. So settlements are actually pretty common. Just in litigation alone,
Yeah.
typically only 3% of cases actually go to trial. Typically, one side can read the writing on the wall and the parties are negotiating all the way up to the end. And typically, litigation gets more expensive as we go. So where filing the complaint might cost, let's just say it costs $1,000 to draft and file a complaint. It's a little bit more expensive, but let's say it's $1,000. By contrast, by the time you get to trial on a daily basis, you're probably spending more like 10 or 15 or 20 times that. So it gets much more expensive the further we go down that road. And then you still have the uncertainty of who's the jury or who's the judge and how are they going to rule. And that kind of pushes the parties one way or another. It's typically far more economical to go ahead and settle. And the other benefit in terms of trade secrets is that, oftentimes when we're talking about trade secret theft, sooner or later the details of the trade secret come out, which means that it's not a trade secret anymore. Mm-hmm. So there are good reasons to settle before you actually go to trial, if at all possible.
Looking ahead, are there changes or developments in trade secret law that you advise businesses to be aware of? Are there any major shifts in how these laws are enforced or interpreted?
I do think that there is a trend towards requiring a little bit more in terms of protection. Things like AI and blockchain are introducing programs, for example, that can actually track on with an immutable record who has had access to different software tools. You can restrict who gets access on a more granular level and track it, so you can demonstrate who has had access to a particular trade secret. Wow. The other thing is that on the flip side of that, with the advent of things like AI and the ability to develop new products and to create code pretty easily with the help of artificial intelligence, I think you'll also have to consider whether or not how easy it is going to be to reverse engineer something. There may be things that you wouldn't have disclosed in the past because you thought that you could keep them a trade secret, where now AI tools and other programming may make it possible to pretty readily and easily go ahead and figure those out. So you might be pushing people more towards filing patent applications in those cases.
Yeah, that's really interesting. I mean, obviously we all know that AI is going to change everything, but even this, it's wild to think about. But you're right, we can easily reverse engineer stuff now.
Yep.
All right. Well, thanks for tuning in to Rock Solid IP, expert strategies for creating real value from creativity and innovation with Rob Wells. To connect with Rob, head to rock-ip.com, and please like and subscribe our channel and leave us a review in the comments. Rob, great to hear from you. That was a great conversation. Really enjoyed it.
Absolutely, Kevin. Thank you. I enjoyed it too.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.